Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Welcome to the October 21 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Federalist Society. We conclude this October sitting with United States v. Tsarnaev, a case which concerned procedural elements of Dzhokar Tsarnaev's capital sentences pertaining to the 2013 Boston Marathon bombing. Joining me today to discuss this argument is Richard Broughton, Associate Dean for Academic Affairs and Professor of Law at Detroit Mercy. Professor Broughton previously served in the Criminal Division of the U.S. Department of Justice and as Assistant Attorney General of Texas for capital and post-conviction litigation.
One of the biggest criminal cases of the October 2021 term at the United States Supreme Court sits at the intersection of terrorism and capital punishment. United States v. Tsarnaev asks two distinct questions that go to the heart of a capital jury's work in a high-profile terrorist case that implicates the death penalty. What should jurors have to reveal about their knowledge of the case from pretrial publicity? And what evidence do jurors need in order to determine whether the terrorist's crime is sufficiently mitigated to warrant a life sentence rather than death? This case involves an infamous crime, the 2013 Boston Marathon bombing, which killed 3 people and injured over 260 other people. Dzhokar Tsarnaev, along with his brother Tamerlan, detonated 2 pressure cooker shrapnel bombs near the finish line of the marathon on Boylston Street. The bombs killed Crystal Campbell, Lingji Liu, and 8-year-old Martin Richard. 3 days later, after being identified as the perpetrators, the Tsarnaev brothers loaded a car with pipe bombs, a shrapnel bomb, and a handgun, and while fleeing Boston, drove past the Massachusetts Institute of Technology. There they shot and killed MIT police officer Sean Collier. They also carjacked a graduate student and stole $800 from his bank account, then fled in the student's car. The brothers then had a violent confrontation with police in Watertown, resulting in serious injury to one officer. There, after Tamerlan had been wrestled to the ground, Dzhokar ran over his brother in the stolen car. Tamerlan later died. Dzhokar was eventually captured after hiding in a boat behind a private home in Watertown. The stories of those killed and injured in the attacks were horrifying. Moreover, the investigation revealed that Dzhokar and Tamerlan were committed jihadists. Dzokar's social media activity indicated his consumption of jihadist literature and propaganda, including Al-Qaeda publications that encouraged terror attacks against the West and gave instructions on bomb making. While in the boat in Watertown, Dzhokar scrawled a manifesto that accused the American government of killing innocents, that he couldn't stand to see such evil go unpunished, and that, he said, the Mujahideen had awoken. Dzhokar was indicted by a federal grand jury on 30 counts, including capital offenses. He was tried and convicted in federal court in Boston, though he made extensive efforts to change the venue of the trial, basing his motion on claims of prejudicial pretrial publicity. Those efforts failed, and after his conviction, he was sentenced to death, following a separate capital sentencing proceeding under the Federal Death Penalty Act. On appeal, the First Circuit affirmed in part and reversed in part, and after the Supreme Court granted certiorari, the case was argued in the Supreme Court on October 13th. The court is hearing 2 issues in the case. The first issue is whether the trial court sufficiently inquired about the pretrial publicity to which prospective jurors were exposed. The prospective jurors completed a lengthy questionnaire that included inquiries about their primary sources of news, how much news they consumed about the bombing, and whether they formed an opinion about Tsarnaev's guilt based on the publicity they'd seen. Then the court and the parties conducted 21 days of individualized voir dire, asking remaining prospective jurors about their questionnaire responses and whether they could decide the case based on the evidence. Tsarnaev claims this was inadequate. He claims that the court should have engaged in content questioning, asking for narrative accounts from prospective jurors about their specific exposure and how the news accounts they saw affected them. Tsarnaev says the jurors should simply have been asked, "What do you remember hearing about the case?" According to Tsarnaev, the trial court was too deferential to the jurors when they asserted that they could be impartial. At oral argument, some justices expressed concern about the First Circuit's resolution of the issue. The First Circuit had determined that the district court violated a 1968 circuit decision called Patriarcha, which requires a trial court to ask content questioning upon a defendant's request and when there is significant potential that jurors have been influenced by potentially prejudicial material. Justice Thomas, who led off the questioning, wondered what the appropriate test was for reviewing the First Circuit's judgment. Was it simply reasonableness, or whether the appeals court exceeded its supervisory authority? And Chief Justice Roberts questioned whether Patriarcha was really a rule at all, as opposed to a mere precedent. Justice Sotomayor, by contrast, thought the application of Patriarcha was sensible here. The jurors consumed a lot of different kinds of publicity, she said, and Tsarnaev simply wanted to know how they were affected by what they saw. For example, if a juror said what she saw had haunted her, both the defense and the prosecution would want to know that, according to Justice Sotomayor. The second issue in the case, and the one that occupied most of the court's time in oral argument, concerns the power of the trial court to exclude mitigation evidence at the sentencing phase of a capital trial, and whether doing so violates a capital defendant's Eighth Amendment right to present mitigation. In September 2011, there was a triple murder in Waltham, Massachusetts. A man named Ibrahim Todashev was investigated, and Todashev eventually implicated Tamerlan Tsarnaev in the killings. The murders today remain unsolved, and both Tamerlan and Todashev are deceased. In fact, Todashev was killed after he attacked federal agents, who were interviewing him in connection with the marathon bombings. At the sentencing phase of his trial, Dzhokar Tsarnaev wanted to admit evidence of his brother's involvement in the Waltham murders. This is because one of Dzokar's claims for mitigation was that he was heavily dominated and influenced by Tamerlan. This, he says, mitigated his culpability for the marathon bombing, in which he was simply following the lead of his brother, who was responsible for radicalizing him. But the trial court excluded this evidence on the ground that it was insufficient and would confuse jurors. The murders were unsolved, both Tamerlan and Todashev were dead and thus be unavailable to testify, and therefore it could never be established what Tamerlan's actual role was, if any, in the Waltham murders. During oral argument, Justice Alito expressed concern that admitting this evidence could have resulted in a kind of mini-trial on the Waltham murders. The Chief Justice and Justice Barrett seemed to agree that this would have distracted the jurors and confused the issues in Tsarnaev's case. Justice Kagan, however, expressed concern that the district court had taken the issue away from the jury. Whether the evidence of Tamerlan's involvement was credible or reliable, she said, was a question for the jury. But if the jury concluded that Tamerlan was involved, that could have convinced at least one juror that Tamerlan was sufficiently intimidating to Dzhokar that this reduced his culpability for the marathon bombing. Tsarnaev's strongest points here relate not simply to the rules of evidence, but to his broader Eighth Amendment claim. A long line of capital cases support the idea that capital defendants should liberally be permitted to introduce mitigating evidence. Tsarnaev's mitigation claim, though, has consequences for other terrorism prosecutions as well as non-terrorism death penalty cases. If his claim is that he lacks sufficient culpability because he was radicalized by and following the lead of someone else, well, that would seem to be true in most any terrorism prosecution. The key question may be not whether he was radicalized and influenced by another, but rather what the terrorist did with, what choices he made about his radicalization. A decision in the government's favor, therefore, could well rely not just on the nature of the mitigating evidence, but on how it is weighed. After all, even if we accepted Tsarnaev's claims as really mitigating, lessened culpability is not the same thing as no culpability. Under the Federal Death Penalty Act, the aggravating factors must simply be sufficient to outweigh the mitigators. And this was a highly aggravated case. Even if the trial court had admitted the Waltham murders evidence, the other evidence of Dzokar's participation in the bombings, his jihadist motives, and the brutal nature of the bombings could likely have been sufficient to warrant a death sentence anyway. Tsarnaev, after all, was able to admit other evidence of his reduced culpability due to his brother's personality, and the jury sentenced him to death nevertheless. Consequently, although the court did not devote time to it at oral argument, the government could benefit from its reliance on two additional points in its briefing, and they're both worth noting. One, that the standard of review here is abuse of discretion, which is more favorable to the government here, and two, that any district court error was ultimately harmless. Although Tsarnaev's case is not directly about the validity of capital punishment, it does raise additional questions about the federal government's approach to enforcing the federal death penalty. The Trump administration pursued a robust federal death penalty, carrying out several executions and seeking the death penalty in many cases. But the Biden Justice Department, under Attorney General Merrick Garland, has promised a moratorium on the federal death penalty. If Tsarnaev wins, the government will have to decide whether to seek the death penalty again in a new sentencing proceeding. If the government prevails and the death penalty is reinstated for Tsarnaev, the government will have to decide when or if his death sentence will ever be carried out. And that may well depend upon death penalty politics and national security politics well beyond this one case. The court's decision in the Tsarnaev case is expected by next summer.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.